over the course of a year, we managed to put together a set of trial transcripts for most of the people who had forensic science during their trials, during their original trials, before they were later exonerated by DNA testing. And the study was then to look at all of those trial transcripts and to review the forensic science testimony to see whether or not it was valid. So out of the 137 cases where we found forensic science testimony, 60% of those exonerees had what we call invalid testimony during their trials. And what we mean by invalid is that the testimony was not supported by empirical evidence. It was unscientific or inaccurate. We don't mean anything in the sense of improper or something about the state of mind of the forensic scientist. We don't know whether the reason why their testimony was invalid was because they were intending to say something wrong, or whether they were negligent or just inexperienced or poorly trained. Those are not issues that we can get into. You can't tell that from reading the trial transcript. All we can tell is that in some of these cases they offered an inaccurate statistic. They gave the wrong frequency or probability. In other cases, they claimed empirical support when none exists. Most of the trials were in the 1980s. Most of the trials involved a rape. And because of that, most of the cases that we looked at involved forensic testing of the kind of materials that you would typically see in a rape kit in the 1980s. So most of the forensic testing involved ABO blood typing or serology of mixed fluids from a rape kit. Many of the cases also involved hair comparison, microscopic hair comparison, looking at questioned hairs found from a victim under a microscope to see whether the characteristics are similar to those or could have come from those of the suspect. There are smaller numbers of cases that involved other forensic disciplines like bite mark comparison, fingerprint comparison, fiber comparison, and there are a few troubling cases involving modern DNA testing, some of the more recent trials. There's a case in our set, the case of David Sean Pope, and his trial was in the 1980s. And the National Academy had, in the late 1970s, looked at a particular forensic technique called voice spectrography. And basically it involved analysis of sound waves. There were experts who said they could look at that analysis of sound waves and uniquely link a person to the waves making up their voice. And so they called it, like a voice fingerprint. And they would testify in court about this. The National Academy did a study in the late 70s looking at this technique, and they said it was utterly unreliable. That it should not be used in courts, it should not be used in criminal cases. The FBI stopped using the technique in court. Nevertheless, you still had a group of experts who would testify in criminal cases using this voice comparison technique. And in David Sean Pope's case, the victim had received voicemail messages from the attacker after the attack. And those were in evidence, and the prosecution hired one of these voice comparison experts who said, yes, that's David Sean Pope's voice. It's like a fingerprint. It's that certain. We're sure it's him. Now, obviously, we know now that expert was wrong because David Sean Pope was excluded by post-conviction DNA testing. But what's particularly remarkable is that, unlike most of the exonerees that we looked at, David Sean Pope actually did have a defense expert. Most of these defense lawyers never got funding for experts. Most of these exonerees were indigent. They couldn't obviously afford to pay an expert. And so there was no one to actually contest the invalid things that the prosecution analyst might have been saying. Well, here there was, and the defense hired an expert who quoted from the National Academy report and said, look, this voice comparison technique has been found to be unreliable. The FBI stopped using it. You can't say things about a voice print, uniquely coming from a particular individual. Nevertheless, the court still allowed the testimony, and apparently the jury was impressed by it. Obviously, there was other evidence in the case, but Pope was convicted, and that case should be a cautionary tale. You would want our crime laboratories to care about mistakes and to try to fix them, and for the most part, that hasn't happened. There have been a few crime labs where there have been high-profile audits. When they have occurred, they've been very useful. they've uncovered additional problems and made important reforms. And that's one of the reasons why the National Academy recommends that there be this independent group to monitor forensic science, to develop these standards, and to enforce these standards. Because there's nothing like that. Our system is fragmented. We've learned quite a bit about what happened in these exonerees cases, and now that the National Academy has issued its landmark report calling for wholesale reform of our forensic science system, what's the next step? We want to prevent future wrongful convictions. We want forensic science to be more reliable, and there to be better research and better institutions to ensure quality forensic science. And the next step is to go to Congress, right? And so, the hope would be that there would be federal legislation to create this National Institute of Forensic Science, so that there would be some kind of entity that would be watching, and watching to make sure that forensic scientists don't make the kind of overstated claims that they did in these innocent people's cases, but also watching to in the sense of doing research and making sure that some of these techniques are reliable. When you have so many innocent people convicted based on inaccurate bite mark or hair comparison testimony, you wonder how reliable those disciplines are. It's not something that we talk about in our paper, but it's something that really is. There's a need for basic scientific research.